103. Decision on questions as to disqualification of members. Clause 1. If any question arises as to whether a member of either House of Parliament has become subject to any of the disqualifications mentioned in Clause 1 of Article 102, the question shall be referred for the decision of the President, and his decision shall be final. Clause 2. Before giving any decision on any such question, the President shall obtain the opinion of the Election Commission and shall act according to such opinion. Okay. Article 104. Penalty for sitting and voting before making oath or affirmation under Article 99, or when not qualified or when disqualified. If a person sits or votes as a member of either House of Parliament before he has complied with the requirements of Article 99, or when he knows that he is not qualified or that he is disqualified for membership thereof, or that he is prohibited from so doing by the provisions of any law made by Parliament, he shall be liable in respect of such day on which he so sits or votes to a penalty of 500 rupees to be recovered as a debt due to the Union. Powers, privileges and immunities of Parliament and its members. Article 105. Powers, privileges, etc. of the Houses of Parliament and of the members and committees thereof. Clause 1. Subject to the provisions of this Constitution and to the rules and standing orders regulating the procedure of Parliament, there shall be freedom of speech in Parliament. Clause 2. No member of Parliament shall be liable to any proceedings in any court in respect of anything said or any vote given by him in Parliament or any committee thereof, and no person shall be so liable in respect of the publication by or under the authority of either House of Parliament or any report, paper, votes or proceedings. Clause 3. In other respects, the powers, privileges and immunities of such House of Parliament and of the members of the communities, and the members of the and the committees of such houses shall be such as may from time to time be defined by Parliament by law, and until so defined shall be those of that the House and of its members and committees immediately before the coming into force of Section 15 of the Constitution, 44th Amendment Act 1978. Clause 4. The provisions of clauses 1 and 2 and 3 shall apply in relation to persons who by virtue of this Constitution have the right to speak in and otherwise to take part in the proceedings of a House of Parliament or any committee thereof, as they apply in relation to members of Parliament. Article 106. Salaries and allowances of members. Members of either House of Parliament shall be entitled to receive such salaries and allowances as may from time to time be determined by Parliament by law, and until provision in that respect is so made, allowances at such rates and upon such condition as were immediately before the commencement of this Constitution applicable in the case of members of the Constituent Assembly of the Dominion of India. Legislative procedure. Article 107. Provisions as to introduction and passing of bills. Clause 1. Subject to the provisions of Articles 109 and 117 with respect to money bills and other financial bills, a bill may originate in either House of Parliament. Clause 2. Subject to the provisions of Article 108 and 109, a bill shall not be deemed to have been passed by the Houses of Parliament unless it has been agreed to by both Houses, either without amendment or with such amendments only as are agreed to by both Houses. Clause 3. A bill pending in Parliament shall not lapse by reason of the prorogation of the Houses. Clause 4. A bill pending in the Council of States which has not been passed by the House of the People shall not lapse on a dissolution of the House of the People. Clause 5. A bill which is pending in the House of the People or which having been passed by the House of the People is pending in the Council of States shall, subject to the provisions of Article 108, lapse on a dissolution of the House of the People. Article 108. Joint sitting of both houses in certain cases. Clause 1. If after a bill has been passed by one house and transmitted to the other house, subclause A, the bill is rejected by the other house, or subclause B, the houses have finally disagreed as to the amendments to be made in the bill, or subclause C, more than 6 months elapse from the date of the reception of the bill by the other house without the bill being passed by it. The President may, unless the bill has elapsed by reason of a dissolution of the House of the People, notify to the Houses of Message if they are sitting, or by public notification if they are not sitting, his intention to summon them to meet in a joint sitting for the purpose of deliberating and voting on a bill, provided that nothing in this clause shall apply to a money bill. Clause 2. In reckoning any such period of 6 months as is referred to in clause 1, no account shall be taken of any period during which the house referred to in subclause C of that clause is prorogued or adjourned for more than 4 consecutive days. Clause 3. Where the President has under clause 1 notified his intention of summoning the houses to meet in a joint sitting, neither house shall proceed further with the bill, but the President may at any time after the date of his notification summon the houses to meet in a joint sitting for the purpose specified in the notification, and if he does so, the houses shall meet accordingly. Clause 4. If at the joint sitting of the two houses the bill with such amendments, if any as are agreed to in joint sitting, is passed by a majority of the total number of members of both houses present and voting, it shall be deemed for the purposes of this constitution to have been passed by both houses, provided that at a joint sitting Let's move further. Provide that at a joint sitting, subclause A, if the bill having been passed by one house has not been passed by the other house with amendments and returned to the house in which it originated, no amendment shall be proposed to the bill other than such amendments, if any, as are made necessary by the delay in the passage of the bill. Subclause B, if the bill has been so passed and returned, only such amendments as aforesaid shall be proposed to the bill, and such other amendments as are relevant to the matters with respect to which the houses have been agreed, and the decision of the person presiding as to the amendments which are admissible under this clause shall be final. Clause 5. A joint sitting may be held under this article and a bill passed thereat, notwithstanding that a dissolution of the House of the People has intervened since the President notified his intention to summon the Houses to meet therein. Article 109. Special procedure in respect of money bill. Clause 1. A money bill shall not be introduced in the Council of States. Clause 2. After a money bill has been passed by the House of the People, it shall be transmitted to the Council of States for its recommendations, and the Council of States shall within a period of 14 days from the date of its receipt of the bill return the bill to the House of the People with its recommendation, and the House of the People may thereupon either accept or reject all or any of the recommendation of the Council of States. Clause 3. If the House of the People accept any of the recommendations of the Council of States, the money bill shall be deemed to have been passed by both houses, with the amendments recommendation by the Council of States and accepted by the House of the People. Clause 4. If the House of the People does not accept any of the recommendation of the Council of States, the money bill shall be deemed to have been passed by both houses in the form in which it was passed by the House of the People without any of the amendments recommended by the Council of States. Clause 5. If a money bill passed by the House of the People and transmitted to the Council of States for its recommendations is not returned to the House of the People within the said period of 14 days, it shall be deemed to have been passed by both houses at the expiration of the said period in the form in which it was passed by the House of the People. Article 110. Definition of money bills. Clause 1. For the purposes of this chapter, a bill shall be deemed to be a money bill if it contains only provisions dealing with all or any of the following matters, namely: Subclause A. The imposition, abolition, remission, alteration, or regulation of any tax. Subclause B. The regulation of the borrowing of money or the giving of any guarantee by the Government of India or the amendment of the law with respect to any financial obligations undertaken or to be undertaken by the Government of India. Subclause C. This custody of the consolidated fund or the contingency fund of India, the payment of monies into or the withdrawal or of monies from any such funds. Subclause D. The appropriation of monies out of the Consolidated Fund of India. Subclause E. The declaring of any expenditure to be expenditure charged to the on the Consolidated Fund of India or the increasing of the amount of any such expenditure. Subclause F. The receipt of money on account of the Consolidated Fund of India or the public account of India or the custody or issue of such money or the audit of the accounts of the union or of a state, or subclause G. Any matter incidental to any of the matters specified in such clauses A in subclauses A to F. Clause 2. A bill shall not be deemed to be a money bill by reason only that it provides for the imposition of fines or other pecuniary penalties, or for the demand or payment of fees for license or fees for services rendered, or by reasons that it provides for the imposition, abolition, remission, alteration, or regulation of any tax by any local authority or body for local purposes. Clause 3. If any question arises whether a bill is a money bill or not, the decision of the Speaker of the House of the People thereon shall be final. Clause 4. There shall be a endorsed on every money bill when it is transmitted to the Council of States under Article 109, and when it is presented to the President or assent under Article 111, the certificate of the Speaker of the House of the People signed by him that it is a money bill. Article 111. Assent to bills. When a bill has been passed by the Houses of Parliament, it shall be presented to the President, and the President shall declare either that he assent to the bill or that he withholds assent therefrom, provided that the President may, as soon as possible after the presentation to him of a bill for assent, return the bill, if it is not a money bill, to the Houses with a message requesting that they will reconsider the bill or any specified provisions thereof, and in particular will consider the desirability of introducing any such amendments as he may recommend in his message. And when a bill is so returned, the Houses shall reconsider the bill accordingly, and if the bill is passed again by the Houses with or without amendment and presented to the President for assent, the President shall not withhold assent therefrom.